Child custody cases arise in New Mexico in a variety of different ways. Usually the first is when parties are getting divorced, or if they're separating and they were never married, and they have to come up with a custody plan. The second is when they already have a custody plan in place, but there needs to be some kind of modification. And I want to discuss the different areas that could occur and issues that arise when creating those plans. What parents need to remember is that the courts are going to be focusing on the children's best interest. And that doesn't always mean what the parents want, because the court's going to be focusing on the child's mental health, their physical well-being, and what they need to thrive. The court can use many tools in order to determine the best interest of the child, including a parenting coordinator, an advisory consult, or a guardian ad litem. A parenting coordinator is a neutral third-party professional that works with the parents to devise a time-sharing plan. An advisory consult is a neutral attorney that's appointed by the court to assess the best interests of the child quickly. A guardian ad litem is a neutral attorney that is jointly retained by the parties in order to do an in-depth investigation about what's in the best interest of the children. This could include home visits or interviews with the family in order to give the court a complete recommendation when it comes to custody and time sharing. A parenting coordinator and advisory consult are usually cheaper and can give a recommendation to a court much quicker. However, a guardian ad litem, even though more expensive, can give a more in-depth evaluation for the court when it comes to determining custody and time sharing. In order to make that determination for your case, you should consult with an attorney. There are a couple misconceptions when it comes to child custody cases. The first one I see is when parents talk to their children about the case. That's really not in their best interest. Two is when they ask their child to choose where they want to live. And that's really not fair to them to make them decide if they rather live with mom or dad. And third, I have a lot of clients say, well, my child can just talk to the judge. The reality is they're never going to come to court and testify. And so these are major pitfalls we want to avoid in child custody cases. Finally, I always remind my custody clients that throughout this process, that as long as we are protecting their child's best interests, we'll have a successful outcome.